Judgment in the matter of Barnardo versus Buckinghamshire and others.
Lord Hodge will explain the decision of the court.
This appeal is concerned with the interpretation of a private pension scheme created by Barnardo's for its staff. It is normal in such pension schemes to allow for price inflation in order to protect the value of pensions which members of the scheme receive after they retire. Barnardo's staff pension scheme contained such a provision. It provided that pensions in the course of payment would be increased, and I quote, by the prescribed rate, which was defined as the lesser of 5% and the percentage rise in the retail prices index, if any, over the previous year. The retail prices index was defined as, and I quote, the general index of retail prices published by the Department of Employment or any replacement adopted by the trustees without prejudicing approval. Since those words were adopted in the pension scheme, it has become widely accepted that the Consumer Prices Index, or CPI, is a better measure of price inflation than the Retail Prices Index, or RPI, which is thought to overstate inflation and places employers under a considerable burden to control deficits in their pension funds. Barnardo's has argued that the clause to which I have referred allows the trustees of the pension scheme to adopt a different price index, which they consider a more suitable measure of price inflation, although the RPI is still published as an official index. Members of the pension scheme, who were concerned that a switch to another index would, over time, reduce the benefits which they would receive, argued against this interpretation. The trustees took a neutral stance, but applied to the High Court for a ruling on the definition of retail prices index. The High Court held that the definition did not empower the trustees to adopt another index unless the RPI had been discontinued as an officially published index and had been replaced. The Court of Appeal, by majority, dismissed Barnardo's appeal. Barnardo's now appeals to this court. In a unanimous judgment, this court dismisses that appeal. The court refers to the trilogy of cases on the interpretation of instruments, namely Rainy Sky, Arnold and Britton, and Wood and Capita Insurance Services, for guidance on the weight to be placed on particular interpretative tools in the construction of an instrument. The court notes that the pension scheme is a formal legal document prepared by specialist lawyers rather than the product of commercial negotiation by parties at arm's length. It is also designed to operate many years into the future, conferring rights on people who are not parties to the instrument and who may not have access to expert advice. As a result, the court attaches considerable weight to textual analysis while having regard to the practical consequences of any construction. The court concludes for 8 reasons that the definition does not allow the trustees to select an alternative index while the RPI remains an official index. First, the use of the word replacement points in that direction. Secondly, the word order and grammatical construction suggests that the RPI must first be replaced by another index, which the trustees then adopt. Thirdly, the existence of a discretion on the part of the trustees does not militate against that view, as there were several indices available when the rules were drafted. Fourthly, one expects words and phrases to be used consistently in a carefully drafted document, and it is clear in the appendix that the definition of the phrase in line with the Retail Prices Index envisages an official body replacing or rebasing that index. Fifthly, the court obtains no assistance from a then current Inland Revenue guidance because the drafter of this scheme did not adopt the words which it used. Nor, sixthly, did the superseded 1978 scheme assist because the drafter had altered the wording wholesale in the 1988 rules. Seventhly, the interpretation which the court favours does not lack rational purpose, and the government has changed its official index over time. And finally, the court must construe the pension scheme without preconceptions as to whether a construction favoured the employers or the members of the scheme. While with hindsight it may have been desirable to give the trustees flexibility to switch to another index, the court cannot use hindsight as a tool of construction.
Thank you. The court will now adjourn.